Hello, government students. This is part two of your lecture on civil liberties and civil rights for learning modules 9 and 10. With part one of this lesson, we focused on the liberties that are enumerated, specifically identified in the U.S. Constitution and then in the amendments. But recall that the Ninth Amendment makes clear that the liberties listed were not all there were. It reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So we move to those others now, the unenumerated civil liberties and how the courts have protected them. Here are the objectives that I have for this part. If you step back for a minute and look at the enumerated rights, the one we covered with the last part, you'd start to see a theme. And it's a right to be free of government intrusion in one's person, property, and especially the home. You call this a right to be let alone. That's a quote from the Supreme Court opinion written by Justice Douglas many years ago. The right to be let alone. That was the mindset of the earlier generations of our country. And when government intruded too far into a person's life, a person would challenge the government action in the courts. But when the complaint that the person was making pertained to something that was not enumerated, the only thing the person could point to would be the general due process clause of the Constitution. That became a more common occurrence after the ratification of the 14th Amendment. Which happened in about the late 1800s, when states began an effort to regulate businesses under the principle of police powers, which is a state's power to regulate for the purpose of protecting public health, safety, and even morals. Think of labor laws, for example. In the late 1800s, this is a specific case I'm referring to, the Lochner versus New York case. There you go. That's a picture of the bakery. In the late 1800s, the state of New York had passed a law that limited the number of hours a baker could work in a single week. 60 hours was the limit. And that was part of the state of New York's effort to regulate public health. But a particular baker, Mr. Lochner, I think his name was Joseph, perhaps, or John, something started with a J, anyhow. So when this particular baker complained that that limitation that the New York State Legislature had imposed unjustly interfered with his freedom to choose, along with his employer, how many hours he wanted to work. He considered that New York labor law to be a violation of the 14th Amendment's guarantee of due process. So here he is asserting an unenumerated liberty, the freedom to contract. And he made this argument eventually up to the U.S. Supreme Court. And this is a landmark decision, Lochner versus New York, where the Supreme Court agreed with Mr. Lochner, and they recognized in their reasoning an unenumerated liberty, the liberty to contract. Now, some at the time might have labeled that decision judicial activism because the court was extending the Constitution's protection beyond what the founders had identified and intended to protect. And that argument would insist that for Mr. Lochner to attain protection of this freedom to contract, he would have to convince the country to amend the Constitution to specifically enumerate that freedom. But he didn't have to. That's not what happened here. Instead, the Supreme Court found that the freedom to contract was fundamental to freedom. It was a fundamental right, and thus an aspect of liberty for which people are entitled to due process of law. The state of New York, in that case, did not satisfy the court that it had provided, I guess is the word, provided due process when it enacted its law. It had not justified its law by some critical public health concern. And without satisfying that high standard for its law, the law failed as a violation of due process, general due process in the 14th Amendment. But it didn't, this tendency to recognize unenumerated liberties didn't stop with economic liberties. It just started there during this progressive era after the ratification of the 14th Amendment, where states had just first started regulating businesses for the sake of public health and welfare. Um, that's when you started seeing this happen, this recognition of unenumerated liberties. But the court didn't stop with economic liberties. They moved into other areas as well. It was mostly around, I guess you would see some of the decisions before the 1930s, but it started happening more frequently in the 1930s. And in that time period, the early 1900s, the Supreme Court has recognized a right to travel, a right to marry, a right to privacy in your home, a right of a parent to bring up their children, and specifically to direct the education of their children. These were all unenumerated rights. They are not specifically listed in the Constitution, but there were several Supreme Court cases that recognized that these rights, these freedoms were fundamental, and therefore people were entitled to due process before any government interfered with their freedom to travel, to marry, their privacy rights, the rights of parents. All of these were recognized by the Supreme Court in this time period. And it all culminated with one particular case, Griswold versus Connecticut. So I'll tell you the story of Griswold versus Connecticut kind of briefly. This is the 1960s, and this is about the time when the birth control pill was first released on the market. And it was controversial when it first came out. And Connecticut, the state of Connecticut, had made it a crime for a doctor to prescribe or for any person to use the pill, contraception. It was new technology at the time, and the state asserted the police power to protect public health. Well, not everybody agreed with that designation, that law, and this was sort of a staged lawsuit. A doctor prescribed the pill to a married couple who had consulted him for advice, and he was arrested and prosecuted for violating Connecticut's law that forbid the prescription of contraception. He went to the Supreme Court, or his case ultimately made its way up to the Supreme Court, and the U.S. Supreme Court agreed with him that it was a violation of the 14th Amendment to limit a doctor. Let me explain first how they reasoned it. They reasoned that the law invaded marital privacy. They said that they called it the intimate relation of husband and wife, and the physician's role in one aspect of that relation. Now, marital privacy is obviously not enumerated in the Constitution, but the court reasoned that it was peripheral of other enumerated rights, such as the Third Amendment's prohibition of quartering in one's home, if you recall that. That's sort of a reflection, not sort of, it is a reflection that people should honor, or government should respect the sanctity of the home, the privacy of the home. Then you see the Fourth Amendment right to be secure in your person's houses, papers, and effects. So there again is a notion of privacy in your person, your personal autonomy in your home and in your property. So the Supreme Court identified this sort of zone of privacy. That was the word they used, zone of privacy, that surrounds the home and one's life and all that occurs within the home, including marital privacy, or the intimacy of marriage. And there was born the right to privacy with this case. It's not to say that the court manufactured that right. There was strong foundation in these other laws I mentioned pertaining the right to travel across state lines, the right to marry, the right to privacy in home, bringing up children. All of those were precedent for the Griswold case. But it was the analysis, the reasoning of the court in Griswold that laid a clearer foundation for how the court would go about recognizing unenumerated rights. Um, so that process that I just described there, where the court recognized an unenumerated liberty by virtue of its periphery to enumerated rights, it kind of stands alone in that case. But subsequent cases built on the analysis, they just kind of took it in a different direction. And we call it now substantive due process. And so this next section here is about the modern analysis. So Griswold is a little bit unique in the way that it identified this zone of privacy, but it isn't unique in a recognition of a right to privacy. And modern courts building on Griswold with slightly different reasoning have held that these are rights which are fundamental to freedom. And if you recall in our assignment for the last learning module, you looked at a particular case called Loving versus Virginia, involving the right to marry a person of a different race. And Loving versus Virginia recognized that this right to marry was fundamental to freedom. That was its basis for finding that Virginia's law not only was it a violation of equal protection, but it was also a violation of the 14th Amendment's protection of due process. A later case in 2003, Lawrence versus Texas, recognized a right to engage in homosexual activity. This again is activity taking place within the context of one's home. And so there you get the privacy of one's home. The right to marry a person of the same sex, that was recognized in a 2015 decision of the Supreme Court, Obergefell versus Hodges. And in that case, the court is relying on Loving versus Virginia for its precedent, its recognition of the right to marry being fundamental to freedom. And then in 1972, I'm actually going a little bit back, not a little bit, quite a bit back in time. 1972, Roe versus Wade recognized the right to privacy, including the right of like personal autonomy, choosing whether to conceive or whether to have an abortion or to deliver a child. That being somewhat related to the right to contraception that the Griswold decision recognized. So you have a long list of precedents recognizing that the due process language of the 14th Amendment encompasses all rights that would be considered fundamental to freedom. And so the court over time has developed a way to analyze whether a right is fundamental to freedom. And I'm going to come back to the Dobbs case and tie it in. That question is this question here at the bottom of the slide. Is the liberty, the unenumerated liberty that is being asserted, is that liberty deeply rooted in our nation's history and tradition? If so, then a law that restricts that liberty must be justified by the state through a variety of different tests or rubrics that are balancing the power of the government, the police powers of state governments to regulate public health, safety, and morals against an individual liberty and what is fundamental to freedom. So it connects the freedoms that would be recognized under the 14th Amendment to the history of that liberty and whether over time, over our nation's history and tradition, have we protected that liberty, even though it wasn't enumerated. So that's the current or modern analysis. So let me take you back to Roe versus Wade and the Dobbs decision. Roe versus Wade recognized the right to an abortion as being among the zone of privacy that is reflected in the Third and Fourth Amendments. The right to be secure in your person, in particular, would be a strong foundation to have for the right to an abortion. However, in the Dobbs case, this was the more recent decision that overturned Roe versus Wade. It's a very unique occurrence to see the U.S. Supreme Court overturning a precedent, but they did in a very slim margin, 5-4, and barely 5 even got on board with the reversal of Roe versus Wade. But in Dobbs, the main justice who was writing the decision reasoned that in in our nation's history and tradition, abortion rights have been heavily restricted, and they cited many state laws where states had limited the right of a person to choose to have an abortion, and because of that history, decided that Roe was wrong, that the right to an abortion is not among the liberties that have been protected through the common law, through the protection of this right over the course of our history and tradition. They did not see evidence that had occurred. And this is part of a philosophical interpretation or a philosophy of judicial interpretation. Um, so let me kind of go back over a couple of points here. Um, Whenever the court is trying to determine whether the legislative branch, so in passing a law, whether the legislative branch has unjustly infringed upon a civil liberty or a fundamental right, they're looking at statutes, which are statements of public policy. These are laws that have been written on behalf of constituents, presumably according to the will of the majority. They're supposed to reflect the norms and interests of society generally. Majority rule, right, is determined through the democratic process. That's what legislation is. Um, but sometimes the policies of the majority, when applied, will adversely affect the rights of the individual freedom. And so the court is, particularly the U.S. Supreme Court, is in the position of having to balance. You see in my scale, they're having to balance the police powers of the state to protect the common good with the freedom of the individual or the individual's civil liberties. And that's a really difficult balance to strike. And so the modern court, the current Supreme Court, um, is tending to or seems to feel constrained to the historical understanding of due process. What does it mean, or what did it mean? What did due process mean in when the 14th Amendment was ratified? And that's why in the Dobbs decision, they look back at the state of the law in the 1860s regarding the right to an abortion, and they did not see a clear indication that the right to an abortion was deeply rooted in our nation's history and tradition. And for that reason, they felt Roe was wrongly decided. The bottom line, though, is this balancing act that the court has to manage. It's a difficult balance to strike, and the result is no civil liberty is guaranteed absolutely. None of them are. Not even the freedom to speech, the freedom of the press. As I covered all those enumerated liberties, you should have noticed that all of them have exceptions. There are always cases where liberties, even fundamental liberties, can be limited. They can be restricted to an extent. And that extent is determined by this balance. You know, when has the government gone too far in the infringement of an individual freedom? But just some examples of the restrictions, just to remind you, the right to freedom of speech. I taught y'all about the very limited, but still, there are occasions when censorship of speech is allowed. There are occasions when the practices of religion can be restricted. There are occasions when gun ownership and use can be restricted. And it's just that the modern court now, in determining, whether the government has gone too far, the current court now feels constrained to look at the history of the asserted liberty, specifically with respect to unenumerated liberties. They're going to look at the history of that liberty to determine whether it is fundamental to freedom. But even if it is, such as the freedom of speech and freedom of religion, even when they are deeply rooted in our history or even enumerated in the Constitution, they can be restricted to some extent, again, as a result of this balancing act that the court has to make. All right, that's it for civil liberties. Now we're going to shift focus to civil rights. If you recall, with the last our last the last lecture that I gave you on enumerated rights, I started out with this slide that discussed the difference between civil liberties and civil rights. And this is just to remind you of that difference. Civil liberties is a reference to the freedom of the individual. And as I just mentioned, when you're looking at unenumerated liberties, the current court is looking at the nation's history and tradition to even determine if an asserted liberty is subject to due process. We sometimes call those liberties fundamental rights. Civil rights, though, oh, and also, I forgot just a second, just remember, people are afforded protection of civil liberties, not just U.S. citizens. Civil rights, those are collective rights. This is the obligation of government to treat people equally and provide equal protection under the law. So that's where we're moving to now, civil rights. And the equal protection is the Constitution's guarantee of equal protection comes from the 14th Amendment, not the Bill of Rights. The 14th Amendment, which I've quoted on here, was ratified just after the Civil War, during Reconstruction, and it was intended to guarantee protect or guarantee the liberties of former slaves in particular, because it was they were concerned about the aftermath of the Civil War. The very last clause here of the 14th Amendment says that carry it from no state shall make or enforce any law, blah, 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 nor deny to any person within its jurisdiction the equal protection of the laws. So that language, equal protection, is unique to the 14th Amendment. And it was enacted or ratified during the Reconstruction era and intended to extend protection for former slaves. It's since been extended to other groups, though. It's not limited to just race anymore. The analysis that goes along with equal protection and whether a state has violated equal protection is going to depend upon two things. First, the group that is being treated unequally. So you have to identify a particular group. And then the reason why they're being treated unequally. So we have to look at both of those in determining whether the Equal Protection Clause has been violated. And this grouping and reasoning, it operates on a spectrum. And so think about it this way. There is a reason to treat certain groups of people differently. Age is the easiest one to describe. There are laws that restrict, for example, the right to drive. You have to be a certain age to drive. And so that may be discriminating against a group, young people, children, but there's good reason for that because children are not intellectually equipped to drive a vehicle. To operate a motor vehicle requires a level of maturity. So there you had a group and a reason. That would not be a violation of equal protection. It is treating a insular group, young people, differently, but there's good reason for it. Okay, so that would be an example when unequal treatment is not a violation of the 14th Amendment. But there are other groups or classes where it would be a constitutional violation to treat them differently. And those groups are known as suspect classes. Not that the people themselves are suspicious or suspect, but that the laws treating them unequally are suspicious. And so those laws would be, those suspicious laws then would be ones that treat racial groups, religious groups, or ethnic groups unequally. These are groups of people who've historically been kept out of the democratic process. They weren't voting on the laws that were enacted that treated them differently. They had no say in those laws. So their interests aren't reflected in the laws. And that's why courts will scrutinize any law that treats them differently with the test known as strict scrutiny. African Americans in particular were disenfranchised. They did not have the ability or right to vote. They were denied the right to vote by the political leaders of the former Confederacy. So they did not have a say in the laws that treated them differently. And that disenfranchisement continued for about 100 years beyond the ratification of the Reconstruction Amendments. And so there's different reasoning to give protection or for the courts to protect this group of people, racial groups. And there's absolutely no reason to treat them unequally. And that's why this strict scrutiny test applies. It's sometimes called rigid scrutiny. I believe in the Loving versus Virginia case, they refer to it as the most rigid scrutiny. But here's the test they'll apply to racial classifications. It's the government's burden, so note that the government has the obligation to prove or show that their law has a compelling purpose for the unequal treatment, that their law is narrowly tailored to accomplish that compelling purpose, and that their law is the least restrictive means of accomplishing that purpose. This is a very difficult burden to establish, and there is only one time in American history where a racial classification survived strict scrutiny, and that was a case called Korematsu versus United States, and it involved racial discrimination against Asian Americans during World War II. This was a dark time in American history, where the president and Congress both agreed that it would be okay to force Asian Americans away from their home along the western coast, California in particular, Arizona and New Mexico, and move them into, they call them detention centers. They were camps, essentially, more into the Midwest areas and held there for the duration of the war. And that is an obvious violation of civil liberty. And you would think that the Supreme Court would have immediately invalidated such a law, but they didn't. They didn't in that case because they believed that national security, or they were taking Congress at its word, that national security was at risk, that Asian Americans might be spies for Japan, and therefore they believed at that time sufficient reason to treat them unequally, to deny them their civil liberty. Fortunately, the Korematsu decision was overturned. There was an apology from the president and some reparations. Of course, not undoing the wrong entirely, but at least an effort was made. So that's suspect classes, so laws that treat members of a particular race, religion, or ethnicity differently are considered suspicious and will be subject to this strict scrutiny test that the government will never survive. They will never satisfy that, or they're highly unlikely to. There's no current precedent that would uphold a law in that situation. There are quasi-suspect classes as well. These are mostly limited to just gender. There are a couple of other classes that would fall into that category, but gender is the best example. And those classifications are subjected to intermediate scrutiny. So it's a slightly different test, slightly easier for the government to satisfy, but still the government's burden. They have to show not necessarily a compelling reason, but an important purpose for their law that treats members of one gender differently from the other. And then you have everything else, age being the example that I gave you earlier. When a law treats age-related groups differently, it just has to show a rational basis. And it's actually the person, not the government. It would be the individual's burden to show that the law lacks a rational basis. And that is fairly difficult to do as long as the state government can show some legitimate reason why they have this law, then that law will survive scrutiny under the 14th Amendment's Equal Protection Clause. So that's how it works with equal protection. Again, as I said, this is a two-part analysis where you must identify the group or the class, and then based on that group or class, you will get these rubrics: strict scrutiny, intermediate scrutiny, or rational basis scrutiny that will test the reason or the purpose of the law. Strict scrutiny is the government's burden, and it is a very high burden. It's a little bit easier with intermediate scrutiny, and it's very easy with rational basis scrutiny. But there are other occasions where um, the laws are not part of the discrimination or the violations of equal protection, but rather an effort to provide equal protection. So we're flipping the scenario here to laws that protect equality or uphold equality. And that all starts with citizen activism. We wouldn't have such laws that provide equal protection were it not for the individuals who worked hard, who were politically active, and spoke their minds and organized and assembled and petitioned the government. So you have to lay the credit here at citizen activism. We wouldn't have, Congress would not have gotten busy with these laws had they not been pushed to by the people. So we're going to start, obviously, now that I'm showing a picture of Frederick Douglass, we're going to start with slavery and abolition. Abolition began as soon as slavery began. So the year 1619 is when the first slaves arrived in the New World here in North America, and almost immediately there was a pushback against it. An abolition effort was apparent in historical documents dating back to the 1600s. Abolition over time, abolition laws passed by states in a gradual way over time, state by state. If I click on this link, I'm not going to do it to save time, but you could type it into your browser if you wanted to. It shows you the timeline of how states gradually through the 16 and 1700s began abolishing slavery. The Emancipation Proclamation is probably the next most notable effort. I guess you could go to the Missouri Compromise as well, but in 1863, we read the Emancipation Proclamation that Abraham Lincoln wrote, and although it didn't really work, didn't accomplish abolition in any way, it did reflect the nation's principle. Its moral focus of the Civil War is to end slavery. That's what it would be about from then forward. So it's a significant event, even if it wasn't immediately effective. It was really the 13th Amendment. Yeah, oh yeah, and remember, it only applied to states in rebellion who would be ignoring the president anyway, but still a notable effort. But it was really the 13th Amendment that, when it was ratified just after the Civil War, that's when slavery is abolished. That's when the citizen activism fully came to fruition there in terms of ending slavery. But what it ended was what we call de jure slavery. That's Latin, I think. That's Latin for of law. So no state could pass a law that expressly permitted slavery or any condition of servitude. That's what the 13th Amendment provided. So that's slavery at law, a law that on its face says it's permitting slavery. That's all that the 13th Amendment banned. And so what continued is de facto slavery or slavery-like conditions that were created in the former Confederate states. We would call those black codes. So these were the laws that former Confederate states passed shortly after the Civil War as sort of a workaround. They're avoiding the 13th Amendment because when you read them on the face of the law, it doesn't say anything about slavery or race at all. But it's applied by the state in ways to create slavery-like conditions for African Americans. Examples I'm giving here are vagrancy laws. These were laws that many states passed that limited the right of a person to be out in public and not at work. So you think of a vagrant now, you probably think of a homeless person, someone sort of wandering the street aimlessly, nowhere to go. That's the way we look at it now. But for the Black Codes, when these vagrancy laws were first enacted, they were focused on African Americans who could not find work and would be, if they were seen around town, if they weren't in their home or on the property of a white man working, they were considered a vagrant and they would be arrested. There were other restrictions also on the jobs that African Americans could hold. So that kind of limited African Americans. They had no other option than to go back and work on the farms and plantations where they had previously been held as slaves. They had no option but to continue working there. Otherwise, they would be arrested as violating one of these black codes. So that's de facto slavery that continued even after the 13th Amendment. Um, in 1896, the U.S. Supreme Court heard a challenge to these would be the Jim Crow laws. So these were getting beyond just the initial black codes, the Jim Crow laws that segregated public accommodations. Plessy versus Ferguson involved separate railroad cars, so transportation is your context here, separate cars for railroad transportation. But in that case, the U.S. Supreme Court said that separation, as long as the accommodations are equal, would not violate the Equal Protection Clause. So it gave legal validation for segregation in the Plessy versus Ferguson decision. Um, Obviously, we know that the separate accommodations were not, in fact, equal, that segregation was wrong. And we know that clearly because of the work of these gentlemen and also the women. They're not pictured, but should be. These are the big six civil rights leaders who showed the courts their error in Plessy versus Ferguson. They lobbied Congress and President Johnson and President Lincoln, President Kennedy before him, to pass the Civil Rights Act and actually end even de facto slavery, indiscrimination in public accommodations such as hotels, restaurants, trains, buses, and so forth. Those things would not have happened were it not for the hard work of those civil rights activists. The Civil Rights Act did a lot for us, and it also helped with education. So we look at that specifically for a minute. Segregated schools absolutely were not equal. And so in Brown versus Board of Education, the U.S. Supreme Court recognized its error in Plessy versus Ferguson, overruled Plessy versus Ferguson, and held that segregation was not equal, that it was a violation of the Equal Protection Clause, and it ordered the integration of public schools. The integration of public schools did not happen immediately. Many states refused to integrate. Some governors closed their public school systems, refused to enforce the policy. President Eisenhower had to send the National Guard to the University of Arkansas, for example, to integrate that state university. This was a time when white people would flee the more urban areas of society and create private schools that only white children could afford to attend. So you see a reaction to the Brown decision, a delay in implementation. That's an example of what I taught y'all about earlier, the problem of judicial implementation that was recognized as far back as the Federalist Essays with Alexander Hamilton. States did not comply. They did not follow the order of the Supreme Court. It took the aid of the executive branch, the president, to force the compliance with the Supreme Court's decision. But it also required Congress to act as well. So that Civil Rights Act that I was mentioning earlier with respect to public accommodations, included Title VI. I think that's, yeah, 6. And that was extending its protection to education, to public education as well. So we had that in 1964 to force the integration of public school system. But there were other reasons why integration didn't, even after the Civil Rights Act, didn't immediately occur. And that has to do with zoning, or due in large part to zoning. The way schools are assigned, or students are assigned to school, it often depends on where you live. So, one segment or a zone of a community would go send their children to one school, and then a different area would send their kids to a different school. So the integration, even though it was required by the Civil Rights Act, it wasn't working very well because of the zoning laws that underlie the assignment to one school. Busing was an effort by Congress to overcome, um, excuse me, an effort by local communities to overcome this flaw in the school zoning process. So they would bus children from one side of a community to another side in order to attend the school there, in order to kind of create an integrated school system. It was controversial. I don't think it occurs anymore, but this was like in the 1980s when that effort was made. Um, but here, let's look a little bit more at this zoning issue that I was mentioning. Um, the the residential areas were segregated, obviously, because of white supremacy. White people deliberately moved away from areas where Black people or African Americans were living. And then also, African Americans, because of the Black codes and Jim Crow laws, could not get jobs to earn money to afford homes that would be in white communities. And so the result of that was the segregation in residential areas, which in turn contributed to the problem of integrating public schools because schools are zoned by by the residential areas in the community. So it all kind of works in tandem and creates a bigger problem. Um, another way that another thing that kind of led to um, segregated neighborhoods were restrictive covenants. Neighborhood associations would form or write these rules that govern their neighborhood, govern the property in their neighborhood that prevented people from selling their homes to minority groups. So that also contributed to segregated neighborhoods. And then another really big problem had to do with um, redlining, the process of redlining, and that has to do with the banking and mortgage lending industry. And so I'm going to play a quick video here that describes what redlining is and how mortgage lending contributed to segregated neighborhoods.
What is redlining? Redlining is a discriminatory lending practice denying access to federally backed mortgages and loans to certain communities based on race and ethnicity. It all started in the 1930s. During the housing crisis of the Great Depression, real estate moguls such as Springfield's Harry Kissel laid the groundwork for the National Housing Act of 1934. From this, a new federal agency was formed, the Homeowners Loan Corporation, and with it, residential security maps that became the standard to determine the best places for housing investments. White communities with strong racially restricted deeds were given a grade A rating and identified as desirable for lending purposes, while Black communities, regardless of their economic status, were given a grade D rating and branded as hazardous and high risk. No federally backed loans would be made there. Redlining locked out millions of Americans from accessing mortgages and stunted opportunities for Black families to build wealth to pass down to future generations. Although the practice of redlining was outlawed with the signing of the 1968 Fair Housing Act, the damage was done. Segregation was embedded in our cities and suburbs. Living in segregated communities has modern day consequences, including sharp disparities in family wealth, education, and life expectancy. These maps were made more than 80 years ago, and yet they still tell a story that impacts us today, the story of redlining.
Okay, that's just a description of one of the major contributors to discrimination or segregated neighborhoods that contributed overall to a problem with housing, unequal housing opportunities. But as the video mentioned, the Civil Rights Act in 1968 was amended to include the Fair Housing Act that made redlining illegal. Although, as the woman in the video explained, it did not cure the problem entirely. We still see the residual effects in our communities even today. Okay, moving past housing now. We'll talk about voting, and this will be the last subject that we have involving racial classifications. You may recall that the Reconstruction Amendments included the 15th Amendment, which guarantees the right to vote without regard for race. And so, similar to the 13th Amendment, the 15th Amendment ended de jure restrictions on voting, meaning at law restrictions. States could no longer enact a law that specifically said certain races of people cannot vote or must jump through some hoops in order to vote. But even though those laws went away, the de facto restrictions on voting continued. And here are just some examples of what they were. One was literacy tests, and the literacy tests were administered by the registrar at the voting office. So when a person went in to register to vote, all people, not just Black people, whenever any person went in to register to vote, they would be asked to complete a test on their knowledge of U.S. government and U.S. history. And these tests, even though the law said they apply to all voters or all people registering to vote, the person who chose which questions that you took on the test was the person at the desk who is administering the test to you, the registrar. And of course, the registrar would often be a white man or a white woman, a white supremacist who would present the hardest questions for African Americans to answer, impossible questions to answer, questions that most people wouldn't know. So that reduced the rate at which African Americans could vote because most anybody would not be able to answer those tests or the questions, those more difficult questions on those tests. In addition to literacy tests, many states enacted legislation that required a fee or a tax when a person went to register to vote. And those fees were insurmountable for most African Americans because of the Black codes. They were not able to gain employment that provided enough money to them to afford to pay the taxes. But even with poor white people, remember these laws apply to everybody, not just Black people. That if it only applied to Black people in the face of the law, it would be a de jure restriction prohibited by the 15th Amendment. So you had to have the way the laws were applied in a discriminatory fashion. That was what continued de facto restrictions. So as far as poll taxes would go, the law itself allowed a loophole. It was called a grandfather clause that said if your grandfather was able to vote, then you don't have to pay the poll tax. Well, of course, African Americans' grandfathers were slaves, so they weren't allowed to vote. So that meant they had to pay the taxes, which, as I said, was not affordable by most African Americans. Another way that discrimination continues through white primaries. When we were talking about, if you remember, the presidential election process, political parties will hold primaries. That's one step in the process of electing a president or a member of Congress. Each party, the Republican Party, the Democratic Party, even third parties will hold primaries in which they identify their nominee for the office. And political parties are private organizations. They are not state operated. So they aren't affected by the 15th Amendment or by some of the laws that would have prohibited the state from discriminating. They didn't apply to political parties. So the political parties would hold primaries and they would not allow African Americans to attend them. Only white people could attend the primary, which means only white people would choose the nominee of that political party. And usually the nominee of the white political or predominantly white political parties would be unopposed, or any opposition would not be able to get enough support. So in the end, the white primary became the means of electing members to Congress or members to state legislatures as well. So white primaries was another way, along with poll taxes and literacy taxes, that these de facto restrictions on voting continued even beyond the 15th Amendment. In 1965, there was an amendment to the Civil Rights Act. We actually call it that amendment, we call it the Voting Rights Act. of 1965, it banned or forbade literacy tests, poll taxes, and it handled that problem and got rid of it. Part of that act, though, um, provided there any state, particularly with respect to redistricting. If you remember our study of Congress and redistricting, um, the states that had a history of discrimination of these literacy tests and poll taxes, those states had to have any sort of redistricting rule or any other voting regulation approved by the Attorney General of the U.S. or some other designated person to determine if that new regulation, voting regulation, would discriminate against African Americans or some other minority group. So this was a measure of oversight that came with the Voting Rights Act that was meant to prevent states from once again circumventing the law and continuing to discriminate against African American voters. And not too long ago, that procedure is called pre-clearance, that approval process. Not too long ago, about 12 years ago, the U.S. Supreme Court in Shelby County versus Holder, they invalidated the pre-clearance requirement of the Voting Rights Act. So we no longer have that part of the Voting Rights Act. You could still sue if you contend that a state regulation on voting is unfairly discriminating against you on the basis of your race. You can still file a lawsuit against your government for violating the Voting Rights Act. It's just harder now because that pre-clearance requirement is gone. So it requires someone who's got the means and the time to pursue a lawsuit. And there are several that have occurred. There was one filed in South Carolina just this past summer, one just the summer before that. There are organizations who've taken upon themselves to enforce the Voting Rights Act by filing private lawsuits against the governments when they believe discriminatory practices are continuing. Now we'll move to gender, and I don't have quite as much to go over with gender. Not that it's any less important, just there's less material that I have available for you. Historically, discrimination against women took the form of something, or kind of the philosophy. It took the philosophy, or applied the philosophy of coverture. You may have heard the word coverture for it sort of means that the woman's identity is covered by the man, whether the man is her father or her husband, whatever patriarchal authority figures in her life would cover her identity so that she has no separate political identity. That's what coverture meant. It's more than just taking your husband's last name. You essentially give up your own identity when you get married. And so that was the history of it, of discrimination. That is why women couldn't own property, couldn't hold jobs, couldn't vote. All of those restrictions kind of grew out of that philosophy. But activism on behalf of the gender began in the 1800s with the work of these women that you see depicted here. I don't remember who is who. If this is one of these people is Elizabeth Cady Stanton, and I don't know if it was this lady or this lady. And then Lucretia Mott was also one of the early activists against gender discrimination. But it started out at an anti-slavery meeting in London. Okay, excuse me. This is Lucretia Mott. I'm getting my facts together now. Elizabeth Cady Stanton, Lucretia Mott, and Sojourner Truth. But Elizabeth Cady Stanton met Lucretia Mott at an anti-slavery, an abolition meeting in London in 1840. And they were attending that, hoping to participate alongside the men involved in the abolition process. But they were not allowed to attend the meetings because they were women. And that made them angry, understandably so. So they decided then and there that they were going to form their own organization to advocate against abolition, but also against discrimination, gender discrimination as well. And they were joined by people like Sojourner Truth and some of the other women of the movement, Frances Ellen Watkins Harper, Mary Ann Shadd Cary. These are just some additional names who joined them in this movement. Um, oh, there you go. They held their first convention, so this will be the first convention opposing gender discrimination, occurred in Seneca Falls, New York in 1848. The women who attended there were asked to sign something called a Declaration of Sentiments. And I don't have a copy of it for you, but if you look it up on the internet and read it, you'll see it sounds a whole lot like the Declaration of Independence, and that's by design. They have made an effort to include women in the Declaration of Independence. They reworded it in a way to include both genders. And there was even some discussion of including suffrage rights, so the right to vote. And that made this Declaration of Sentiments pretty controversial, or somewhat controversial. Anyway, there was a very progressive effort, though, to include the right to vote. But it was mostly the Seneca Falls Convention was mostly about recognizing the equality of the genders. Um, and again, freed slaves were involved. So it was wrapped up in the abolition movement. The feminist movement was kind of ran part and parcel with the abolition movement. But it continued into the 1900s. Several organizations were formed to advocate for women's rights. The National American Women's Suffrage Association is one of them, National Women's Party. They had varying degrees of what would be the word? Aggressiveness, perhaps. Some organizations were a little bit more extreme than others, but they were both all working for the same goal. And by the early 1900s, that goal was the right to vote. That was essential to being a full citizen in the U.S. was to have the right to vote. And it succeeded the state level even before we got the 19th Amendment. The 19th Amendment was ratified in 1920, giving women the right to vote nationwide. But even before that, states began recognizing the right to vote through the activism of these women, these feminists of the early 1900s. But their efforts continued, didn't stop with the right to vote. They began focusing on equality in education, equality in the workforce. The Civil Rights Act was one part of it. An amendment to it was passed in 1972. Oh, excuse me. I forget what year it was passed, but it included one of the titles of the Civil Rights Act included equality for women in education and accommodations and such things. In 1972, however, the women's rights movement prepared an amendment to the U.S. Constitution, a proposed amendment to the U.S. Constitution called the Equal Rights Amendment. It meant to extend the principles of the Declaration of Independence to men. So it looks a lot like the 14th Amendment, but it makes clear that gender is part of that equality guarantee. Congress approved the proposed amendment in 1972, and so the amendment was circulated out to the states. And only recently did we get enough states willing to ratify the amendment. Unfortunately, the deadline for ratification has passed, so it's kind of stagnated right now. We may not ever get an equal rights amendment, or it may, they may be able to amend or revise the amendment to extend this ratification deadline so that it can actually be so that it can actually go into effect. I mentioned the Title IX of the Civil Rights Act, that it actually was 1972. I had that correct. That was the year that the Civil Rights Act began including equality in education for women with Title IX, and particularly in athletics. You might hear of the Title IX process of including equal facilities and equal opportunities for women in public education, particularly higher education, such as Lander University, making sure that women have equal access to athletics and, in general, equal access to education. There are lingering effects, just like there are lingering effects of racial discrimination. There are lingering effects of gender discrimination that we see, particularly women are underrepresented in politics, in Congress in particular, underrepresented in positions of authority in the business world as well. So I'm not sure that we've reached full equality in terms of gender. Definitely not in terms of race. We still have a lot of underrepresentation of the racial makeup of our government. But progress has been made thanks to citizen activism. Um, your textbook discusses an interesting concept that I'll touch on for just a minute. Um, it's known as the doctrine of comparable worth. And it's sort of interesting to think about how we determine the salary of particular, different jobs. Why do jobs that are traditionally held by women pay less than jobs that are traditionally held by men? That's the question that's presented by this doctrine. Um, and the idea is that this difference, inequality in pay, is the result of the past um, belief that women should be paid less because they should be covered by their husband. Their husbands should be earning enough money to provide for them, so they don't need to earn as much money. They're not having the responsibility for supporting the entire family. That would have been their husband's job. So women would get paid less under the presumption that if they're married, they don't need any more. That inequity has carried forward, or at least that's the argument of the doctrine of comparable worth, that has carried into inequality in the pay, the salary that is paid for positions or jobs that women tend to hold as opposed to men. You just read that part of the textbook, see what you think, whether you think that's valid or not. All right, that's the end of this lecture for Learning Module 10. If you have any questions, send me an email. If not, go ahead and get started. There is just two learning module assignments. Before I end the PowerPoint, let me go back so I can explain that real quick. So, one of your assignments is to read Dr. King's letter from a Birmingham jail. So it was written in the 1960s when Dr. King had come to Birmingham to participate in some efforts to end segregation in businesses, local businesses in the Birmingham area of Alabama. And while he was there, he was put in prison for participating in some protests. And they wouldn't bring him a sheet of paper or a pencil to write, but they did bring him the news. So while in prison, he read a news article that had been written by some other clergymen of the area. Some of the pastors at the local churches in Birmingham got together and wrote a public letter that got published in a newspaper criticizing Dr. King's presence there in Birmingham and his efforts. And so it bothered him enough, sitting there in jail reading that he decided to respond to it. And he took that newspaper, got a jailer to bring him a pencil, and in the margins of that newspaper, he wrote a beautiful letter. It's one of the most, what I'm not sure what the word is, but it's a amazing letter that he wrote, um, explaining his presence there and explaining his philosophy and the efforts of civil rights and why the time was now that he had to be there. He had to pursue this effort and not wait for the legal challenges that have been made against the discrimination in restaurants and hotels, to not wait on that he had to protest even while those efforts were pending because the need was there. The need was now. And he explains that so well that I want you all, that's actually one of the required founding documents of this course, is to read that entire letter. Please don't skim over it. It's worth the read. Read the whole letter. I've got some questions that are based on the letter for you to answer as one of your learning module assignments. And then I believe there's a quiz that goes along with this learning module. Also, I believe I may have skipped over something with due process. So I want to go back just for one moment. Yes, here we go. Um, flip back in your notes just for a minute to where we were talking about the modern analysis of identifying an unenumerated civil liberty. And I was making an effort to explain substantive due process for you. And remember, substantive due process is a means of interpreting the 14th Amendment, the due process clause of the 14th Amendment. What does it mean? So let me explain that just a little bit more. The word due process, if you look at the word, you see process, you think procedure, right? What procedures are due to an individual when a state is attempting to place limits on life, liberty, or property. So whenever a state is taking some sort of action or has passed a law that infringes on the freedom to live, the freedom to be to pursue a job, or the right to hold property, anytime life, liberty, or property have been restricted in some way, what are the procedures that are due? What must a government do before it can deny a person or restrict a person's right to life, liberty, or property? That would be called procedural due process. What procedures are due? How government action, that's if you want a definition of procedural due process, it's how government action is fair. What is fair? What is due when a person stands to lose their life, liberty, or property? And so you see these procedures outlined in the Fourth, Fifth, Sixth, and Eighth Amendments. Their job is to enumerate some procedural due process. But there's also a substantive element of due process. So what laws or actions are fair? So due process means fair law. It's not just fair procedural law, it's fair substantive law as well. So with procedural due process, we're looking at the how, the actions government must take before it can deny a person's right to life, liberty, or property. Substantive due process is what laws are fair. So that's where we go back to the right to marry. That is a law that is not fair because the right to marry is fundamental to freedom and has been, as we know with the modern analysis, the right to marry is deeply rooted in our nation's history and tradition. So any law that restricts it would be a violation of substantive due process. All right, so I just want to make sure you understood that distinction before I end the lecture. But now, for real, I am actually ending this lecture and asking you to proceed with your assignments for this class, or for this learning module.